Good afternoon.
Good afternoon, sir.
Okay, shall we start?
Yes, sir.
Okay. Today we're going to discuss about negotiable instruments where checks are involved, collecting of check and payment of checks, and also opening of deposits accounts. The time frame will try to finish it off. Okay. What are negotiable instrument? As bankers, we should be very familiar about this. Where an instrument is by custom of trade transferable like cash, by delivery, and is also capable of being sued upon by the person holding it, it is entitled to the name of negotiable instrument. And the property in it passes to the transferee who has taken it for value and in good faith. Crouch versus Credit Foncia of England, 1873. This was the definition given in this case, the court case. What is a negotiable instrument? Where an instrument is by custom and trade transferable like cash. So negotiable instruments are like cash. It is transferable without any difficulty, without any obstacles. And by delivery, the transferee get the value and taken good profit, good faith. And also, it can be sued upon the person who is holding it. Person who is holding it can file action in the case of a default for any persons in the who have been negotiated previously or straight away for the drawer. Right? So this is the quality where the negotiable instruments are concerned. The negotiable instrument will be instrument by custom, trade transferable by cash, by delivery, and it is capable of being sued upon by person holding it. These are three areas that we discussed a while ago. And the property passes transferee who is taken for value and good faith, entitled name of negotiable instrument. Okay, what are essential features of negotiable instrument? Property and rights in the negotiable instrument passes by delivery alone or by delivery and endorsement. No further evidence of transfer is required. There's no need to sign a document or a receipt when it passes on delivery. And delivery, when it's handed over, the property and the rights both are transfers without any difficulty. Property means the instrument and right means all the legal rights incorporated to that instrument will be passes to the person who takes that. Or alone by delivery and endorsement. There are certain negotiable instruments are there, not only delivery, but endorsement also required. So these are the legal requirements. Let us see what are these, which instrument needed the endorsement. The holder of the instrument can sue on its own name. Right? The holder, he himself can file action in the case of a problem or default or anything in the instrument. No notice need to be given to the debtor, the person who is liable. Okay, debtor who has given the this thing, the instrument, notice should not may not be given. It's necessary. Notice to be given. Valuable consideration is presumed to be given. For a value, the transferable transfer should be taken place. For a value, the transferee obtains a good title to the instrument, although the transferor's title may be defective, provided the transferee has received the negotiable in good faith. And this is the most important legal part in the negotiable instrument. Transferee obtains a good title, right, in the instrument, although the transferor's title may be defective. This is what very important to understand. We are negotiable instrument like currency note also like a currency note, where instruments when the ownership is doubtful. For example, stolen check. A stolen check is given, negotiated or given to a person. The person who takes in good faith, genuinely he takes that for a value, then he is getting a good title than the person who have been given the check. For example, if you, when you're going on the road, okay, you find some money on the road. You just pick it up the notes. Okay, so you get a better title than the person who earlier who had it. For example, a pickpocket had been robbed a purse from a person and he had dropped the money on the road. You picked up the money and you get a better title than the robber had. That's a what do you call the important feature in is negotiable instruments. Person who has obtained that for a good faith and for a value, he is getting a good, better title and than the transferor's title. Although the transferor have a defective title, right? It's not effective transferee, he is getting a better title. Right? So like a currency note, if a currency note is in your custody, your hand, no one can claim that it is his currency note. There's no proof for it. Similarly, negotiable instruments also the same manner. Okay. So there are major two concepts. One is transferability, other one is negotiability. What is transferability? Transferability is passing the title. Passing the title. That means giving hand to hand. I give my title to person who buys from me. Negotiability means the legal quality of the title. Legal quality. Negotiability is legal quality. So the transferability, if you look at, this is the outer line, and negotiability is inner circle, the quality. So it will not affect the transferability. All negotiable instruments are transferable, but not all transferable instruments are negotiable. All negotiable instruments are transferable, but not all transferable instruments are negotiable. Right? That means transferability relates to the process of passing title in an instrument, while negotiability usually relates to the quality of the title of the instrument passed. Okay? This is the importance of negotiability and transferability. Negotiability, where quality of the title, whether defective or genuine. Transferability means passing the title. One person on the ownership will be shifted. Okay. Types of negotiable instruments are bill of exchange, checks, dividend warrants, bearer debentures, promissory notes, and treasury bills. Not negotiable instruments are money orders, postal orders, fixed deposit receipt, share certificate, letters of credit, bill of lading are not negotiable instruments. These instruments cannot be negotiated. This is the Latin term, nemo da non have, is to give the legal legal position of the transaction. Buyers get no better title than the seller had. Or in other words, you cannot pass a better title than you have. That's called nemo da non have, legal term. If you have stolen goods and transfer that goods to an innocent buyer, he does not get a good title to the goods. He also gets a tainted title of stolen goods. Okay, so refer law of contract about the transaction governed under law of contract. What is a legal title? Union of a legal rights, ownership, possession, and custody, evidenced by legal document, instrument, such as bill of sale, certificate of sale, certificate of title, or title deed. A legal title empowers its holder to control and dispose of the property and serve as a link between the title holder and the property itself. Okay. And, what is the certificate of title? Bill of sale. Yeah. Control and dispose of property and serves as a link between the title holder and the property itself. Between the instrument, that's the property, and the ownership. Link between that is called legal title. Right? Now, if that's what when you certain instrument, when you take as securities, we check for the title, not the ownership. It is beyond the title is beyond the ownership. The legal position of the ownership we call title. Legal position of the ownership. So, if a person steals something and keep it in, he's getting the ownership, but not the title. But in a negotiable instrument like cheque, now the stolen cheque, even stolen cheque is stolen, that is when he gives to somebody, he's getting a better title than the person who stole the cheque. Right, when you talk about the negotiable instrument, we are talking about the cheques. Right? The cheque is a negotiable instrument and how to collect a cheque. What are the legal requirements? Let's see in detail about the collection of cheques. It is governed by the Bill of Exchange Ordinance number 25 2027. Under Section 3 of this ordinance, Bill of Exchange is defined as it's an unconditional order in writing addressed by one person to another, signed by the person giving it, requiring the person to whom it is addressed to pay on demand or at a fixed or determinable future time a sum certain in money to or to the order of the specified person or a bearer. Right, Bill of Exchange, how this is defined is very long. Simply says it's an unconditional order. Bill of Exchange is an unconditional order. There can't be any condition to be incorporated in the Bill of Exchange. That is, after signing a document, or after you deliver the goods, I'll send this will be given, like conditions can't be imposed. It should be in writing, right? Not verbal, and addressed by a person to another, addressed by one person to another, signed by the person giving it, right? Signed by the person giving it, requiring the person to whom it is addressed pay on demand or at fixed or determinable future time. Some certain in money to or the bearer of the specified person or a bearer. Okay, so Bill of Exchange gives as an instrument, normal import-export trade. The Bill of Exchange is used to like an instrument for money transfer, right? What is law-related checks? The cheque is most popular common negotiable instrument known today. Definition: cheque is a bill of exchange drawn on a bank, payable on demand. Section 73 of Bill of Exchange Ordinance. According to the same requirements that are essential to constitute a bill of exchange are required to constitute a cheque. So what is the requirement for bill of exchange? Will be applicable for cheques also. The definition: a cheque is bill of exchange drawn on bank, payable on demand. Section 73 of Bill of Exchange Ordinance. Accordingly, some requirements that are essential to constitute bill of exchange are required to be constitute a cheque. Okay, what are the features to be added to become a cheque? Let's see what is that. There's one major difference. The constitute a cheque, the instrument must be drawn on a bank. There's no commercial or financial institution other than a bank can pay or collect checks. It's very, very important to understand. Right? To consider a check, the instrument must be drawn on a banker. Thus, no commercial or financial institution other than a bank can pay or collect check. This is a major advantage and privilege that bank enjoys. Check is written on a form issued by the bank. Burnett versus Westminster Bank, what is say that, 1966. Check is written on a form issued by the bank. The specific format is used and it is issued by the bank. So the check leaves are homogeneous to all the banks in the same way. Now present truncation and clearing arrangement, checks are in the same size. According to Section 73 of the Bill of Exchange Ordinance, it's a bill of exchange drawn on a banker, payable on demand. Check is defined as an instrument of drawn on a banker, payable on demand. Whenever presented for payment, it has to be paid. We cannot postpone it. Dual aspect of a check, it is subject to Bill of Exchange Ordinance. Right? It's subject to Bill of Exchange Ordinance legally. And it's a mandate issued by the bank, by a bank to the customer. Checks written on the form issued by the bank, Burnett versus Westminster Bank, we discussed it a while ago, same thing. And the format should be common to all the banks. Right? Earlier, checks were written in a normal piece of papers, originally when the checks introduced. In the Burnett versus Westminster Bank case came up, that has been established that the checks has to be written in the format given by the bank. Dual aspect of a check means it is subject to Bill of Exchange Ordinance. It is a mandate issued by the bank to customer. In practice, a check plays a dual role. On the other hand, it is subject to a Bill of Exchange Ordinance and considered as a negotiable instrument. On the other hand, from a from the banker's standpoint, it is a mandate. The check issued by the bank's customer, requiring the bank to pay a stated amount to a stated party on or after the date of the check. So, what are features? Let's see. It's coming. Now, what is this called? A mandate. Check is a mandate. The check issued by the bank, customer requiring the bank to pay a stated amount. That's a given order given by the drawer, owner of the check account, owner, given the order to the paying bank. That is the we call pays bank. Okay, so that is where it is payable to a person or a named person or open check as a cash, and it's a mandate given by the drawer to the drawer's bank, that is paying bank, to honor the check if it is in order according to the legal requirement. Honor the check, to pay the check, without any other requirement, hesitation and all. Now, according to this principle, we'll see some of the practices are also clashing with this. Let's see what are those things that in this slides. Advantage of check as a means of payment. A check dispenses with the need to keep cash and attendant risk of theft and loss. Right? When the check cash is given, if a loss or theft, it can be traced back and it cannot be called it back. But in the check, you can collect it and you can identify it. It can be drawn for an exact amount required. Small exact amount required, where in currency you can't use, but exact amount you can draw the check. Yeah, no problem. It can be dispatched by the debtor to the creditor cheaply and safely without the risk of loss, inconvenience which can occur when settling debt, which can occur when settling debts in cash. Okay. It can be dispatched by the debtor to the creditor cheaply and safely without the risk of loss and inconvenience, which can occur when settling debts in cash. Payment by check also provides a simple and authentic record of a payment of the debt. So, in other words, check, paying by check, the check instrument will be a mode of legal document to prove that transaction has been taken place. Right? It's an authentic record. It's accepted as a legal document to prove the transaction. That's what most of the instances, certain payments to be made, it's insisted no check. Subsequently, we can take the check from the bank and prove the transaction. If there is a doubt or if there's a problem arises. Okay, bank retain the paid checks for 6 years so that you can always get the bank to produce a check to prove your payment. The check has to be retained for 6 years. Why is that? Under prescription ordinance, any written agreement should be kept in for 6 years, or within 6 years only you can take legal action. To file action, within 6 years you can do if there's a contract signed by both the parties. So, mandate of the check is a legal document, therefore. Okay. Payment by check is generally equated to a payment by check cash. A check is a conditional payment when honored by the bank, it is actual payment. DSC builders versus fees. It's English common law. English common law also treated the check as any item of property with value and equal to the amount of which it is drawn. Okay, so this according to English law, right? English common law, the value of the property instrument is equal to amount in which drawn, not above or beyond. Okay, that's the advantage in legally you are getting if you're using a check. Okay, let's see what is collecting of check. What is the relationship between the collecting banker and the customer? The bank, when collecting of a check on behalf of a customer, the customer is the principal, whereas the bank can become an agent. Whenever a check is issued for payment, the relationship in the collecting banker is bank collecting a check on behalf of his customer, and mandate is the check leave. We are giving order. Or no before make the payment. To whom it addressed, the person who taken the got the relevant drawing level, he is becoming the principal, whereas the bank is an agent. So agent principal relationship on the law will be applicable in collecting of checks. The duty of the banker to satisfy that the title of the check has been lawfully and orderly transferred to the depositor, the customer. The bank is liable for the true owner of the check when collected same to a wrong person. Let's see what is this. Duty of the banker to satisfy that the title of the check has been lawfully and orderly transferred. Not the what you call ownership. It is the title. Legal ownership has passed the orderly to the person or the depositor. Right? Then we discussed it later about the depositors got the check, right? And the depositor means he's the drawer, he's the beneficiary, or got the check from the drawer for a value. When bank is collecting bank is collecting a check, bank has to collect to the true owner of the check. True owner of the check. Under Bill of Exchange Ordinance, Section 82, banker's duty liable for true owner of the check when collects same to a wrong person. Okay, so bank is liable only for the true owner. If now for a take a case, consider a case of what you call sales rep. Sales reps open account. Their objective is open account, clear their checks as well as the clear checks and to get the to get the cash, get the check is cleared by the bank. Okay, now sales reps are one of the vulnerable customers for us because this customer of the what you call sales reps, they collect checks, which is for the his principal, right? Now checks are given, maybe cash check, some maybe even checks are drawn in favor of company, and given when this what you call sales reps, they put these checks into his account to collect. Right? Now, if there's a fraudulent check in that, right? Where fraudulent check is that, the banks, when the bank is collect the check on for the sales rep, bank is liable to the true owner of that check. If it's a fraud or taken in not in the proper manner. So bank is liable under Section 82 of Bill of Exchange Ordinance to true owner of the check. That means bank has to pay to the true owner the value of the check if you are collected for wrong person. So that is the legal side of the checks, under the legal side of checks. Right? So therefore, duty of the banker to satisfy that title of the check has been lawfully and orderly transferred to the depositor. Depositor should get the lawfully and orderly. Now, there's a problem. Now, if a collecting bank had to check each and every check deposited to the account, whether it is lawfully and orderly transferred to the depositor by the drawer or the third party, it's going to be a cumbersome job. It's going to be a cumbersome job. But responsibility is not left over. Responsibility is not left over. Therefore, bank is liable for the true owner if a collector for wrong person. So bank has a role to play, collecting banker, to check each and every check collected to the correct party. Now, Section 82 of the Bill of Exchange Ordinance, we'll discuss later about details, is one of the very important law saying that if the bank collect the fraudulent checks, even if the bank has completed four parameters, then the transaction is considered as a genuine transaction. And bank is not liable for the true owner. That's for the negotiability and the legal side, very important. Okay, for example, now I'll come there later. So what are the types of checks? forms of a check. We have an open check or cross check. When this check is not uncrossed, it is called open check. Open check can be a bearer check or an order check. Bearer check as well as an order check. Right? Cross checks are two types, general crossing and special crossing. So let us discuss what are these crossings and what are these transactions taking place, how the checks are. Who are the parties to the check? There are three parties. Any check, there are three parties. First party is called drawee. So you can say start from payee. The payee is the first party. Now the check is drawn to a person, a payee. For a transaction, for a person, it has been drawn the check. Now, for example, a check has been written to Matarage stores. The check is therefore it is addressed to Matarage. The proceeds should be given to Matarage stores. So the collecting banker have a responsibility to see whether the check has been collected to the particular account of Matarage stores. Or any authority is given either Matarage stores or by a power of attorney to somebody else. Okay. So second one is called payee. Drawee is always a bank in a check. The check is by drawer addressed to the drawee by the drawer, addressed to the drawee to pay some sort of amount to the person who named here to pay. Now this check is a printed order check. You can see here, order. So always to give an order, there should be some sort of a physical body as payee. Physical body should appear as payee. Right? Or else it can be an open check where name is can be written as cash, and then here word is not order by bearer. By bearer. Okay? Here by bearer. Now there are most of the checks are bearer checks. Where here under bearer to pay to the bearer. Then there won't be any order from the drawer to pay the bearer checks, no order. So the important part is how to negotiate these two checks. We'll be discussing a little later. The features of a check, the payee is a specified person. It's a physical person or a legal person. B, payable on demand. Whenever a check is presented for payment, it has to be paid on demand. Right? There's a famous case, Great Western Railway Company says, check has been came to the clearing for payment. It has to be honored by the paying banker and the drawer. Right? It has to be honored by the paying banker. Because it's on demand. Whenever presented for a payment, payable on demand. There can be checks where postage checks are written. Their demand is on the maturity date or the due date. And specified amount in words and figures should be specifically noted down. Then order to pay. Check is either can be order to pay or bearer to pay. Right? Here it is this line is deleted for a stroke here. It's becoming a order check. Okay. Right. Signed by the drawer. Drawer had to sign the check on the right hand bottom.  'em. And it's an order to the bank. 'Right? 'Order to the bank' is an order to the bank. 'Order to pay' is an order to pay. 'Order to sign' is an order to sign. 'Order to sign' is an order to sign. 'Order to pay' is an order to pay. 'Order to sign' is an order to sign. 'Order to pay' is an order to pay. 'Order to sign' is an order to sign. 'Order to pay' is an order to pay. 'Order to sign' is an order to sign. 'Order to pay' is an order to pay. 'Order to sign' is an order to sign. 'Order to pay' is an order to sign. 'Order to sign' is an order to sign. 'Order to pay' is an order to sign. 'Order to sign' is an order to sign. 'Order to pay' is an order to sign. 'Order to sign' is an order to sign. 'Order to pay' is an order to sign. 'Order to sign' is an order to sign. 'Order to pay' is an order to sign. What is his order? Giver knew. That's no request. There's no request. It's all always given. So what is, and it's written an unconditional order. These are very important. Very important to understand unconditional order. That means you cannot place condition when you're writing a check. For example, pay to so and so after signing, after producing certain documents. It's a conditional order. Or after supplying the merchandise, only payment to be made. That type of conditions cannot be applied for a check. It has to be unconditional and it should be written. No condition should be attached. Right. Now let's see features of a check. There are a number of features available. These are called statutory features. The first one is the date. First one is the date. What is the date of a check? It's important. 2 is the payee, to whom the check is addressed to be paid. And 3 is the value in figures. Value in verbal, in writing. What is the value? And number 4 is value in figures. Number 5 is the drawer's signature, who is giving this order to the paying banker, right? This order to the paying banker, and give funds to this particular customer, particular payee, on demand, on presented for payment. That's the agreement. Then the other feature is, number 6 is the crossing. Is crossing. The crossing is also a statutory feature of a check. Okay, let's see what are these features in detail. Validity of a check is normally 6 years under prescription ordinance. Validity 6 years under prescription ordinance. But in banking practice, it is 6 months. Therefore, if a check is presented for payment, from the date of the check within 6 months, it has to be paid by the paying bank within 6 months. After 6 months, the check is getting stale. It's called a stale check. You can't pay. Then the validity can be further restricted by the customer. Because it's a customer's order, it's a mandate, it's order. No customer can further request to stop the to reduce the number of days. Right? Now, normally, practically in practice, within 6 months can pay. The customer can say pay the validity limit for 30 days or 6 days. Especially appearing in the government checks. Thereby, you can't pay check, although it's 6 months valid. After 30 days, if the drawer says not to pay more than pay only within 30 days, you have to obey for the what you call that rule. You have to obey for that condition. Right? So we have to accept that it's a mandate. Mandate is called under the law. It is implied contract. It's a contract. Therefore, bank is liable to honor that one. Let's see what is the crossing on a check. What is the crossing? Crossing on a check originated by the practice of by bankers. Crossing were originally placed on the checks only by bankers in the process of clearing. Right? Crosses were given statutory recognition in England by a series of acts commencing with Cross-Check Act 1856. So there is a special act in UK 1856 about the cross-check. But in Sri Lanka, keep in mind, it's not applicable to Sri Lanka. We are getting only bill of exchange ordinance only. Okay, this was incorporated to the Bill of Exchange Act 1982 and Bill of Exchange Ordinance 1927, Section 76 and 77. What is this crossing? Okay, so crossing is the what you call statutory feature of a check. Crossing on a check is a part of the drawer's mandate to the banker, paying banker as well as a collecting banker. Crossing is an order. If it has a crossing, it's an order given by the customer to the collecting banker that not to pay cash to this this check over the counter. It has been deposited to account, through account it has been cleared. Okay, so that's one of the example. Crossing is a legal, it's a part of a mandate, and this is a contract. When it's a contract, part of the condition of a contract is that payable on demand, 1% on payment. So it is the order given to the collecting banker, says collect to a certain people only, and giving the order to the paying bank to pay check is presented for payment within the parameters of the date. It has to be paid. The crossing on check is the direction to the paying banker that the check should be paid only to another bank or an account of a bank. So this is a given direction. Effect of a crossing of a stamp, consequence of paying cash over the counter to a cross check. So when check is crossed, it cannot be used to get cash over the counter. It is a practice in the bank. It has to be opened. The paying banker will liable to the true owner. Paying banker will liable to the true owner when after paying the check. So, but the check is collected by the collecting bank. Paying banker does not know about the ownership of the check. Therefore, in the practice, the bank has to make a certification on the reverse of the check that about genuineness of the check. So then it can be paid to the drawers can be debited and can be paid to the depositor at the depositor's bank with the necessary payments. Okay, the receiver of cash not entitled to receive that payment. Where check is crossed, you can encash over the counter. The paying bank will be liable to the true owner. So if the check is paid to third party, not the true owner, paying bank is liable to the parties. By the paying bank will also forfeit the statutory protection of bill of exchange ordinance. If the check is collected and paid violating the bill of exchange ordinance, then the bank is liable for violating the bill of exchange ordinance. The payment of check, the definitions given in the check paying system by the central bank also given that. Okay, in the practice of bank of we using that. Okay, this consider release of the paying bank will also forfeit the statutory protection of the bill of exchange ordinance. So the paying bank will get a protection under bill of exchange ordinance section 60 gives the protection to the paying banker. Paying banker will, if the paying banker will pay a check in normal course of business and in good faith, two things only, normal course of business and in good faith, and done it, then paying banker's responsibility is over. Okay. The paying banker will be liable to the true owner. The paying banker will also forfeit statutory protection of the bill of exchange ordinance. What is that? 4 feet. The statutory protection of the bill of exchange. Paying banker is protected under Section 60. Collecting bank is protected under Section 82 of the Bill of Exchange Ordinance. It is considered as a negligence in the part of the paying banker if the paying bank, without ignoring that instruction, can do a payment. That means if a crossing is there, if the crossing is there, without taking consideration of crosses, pay the cash over the counter, then the branch cash officer will be liable for breach of contract. Then there are two types of crossings. General and special crossings are dealt with Section 676 of the Bill of Exchange Ordinance. Section 761 say, what is general crossing? Where a check bears across the face the word and company or any abbreviation thereof between two parallel transverse lines, either with or without the word not negotiable. It's called a general crossing. Writing two parallel lines on the face of the check constitutes the general crossing. Simply two parallel lines with or without words not negotiable is very important. Right? With or without the word sign, and it should be open, not negotiable. Right? Okay. Two transverse parallel lines on the face of the check. These are like this, or two parallel lines with word and company. This and company was incorporated in England long time before, because checks were dealt by the business people, companies only. Therefore, this and company is incorporated there. Still, we are using this and company because it is there in our books. But in practice, this and company is no more valid because no one is writing as this crossing like that. Only two transverse parallel lines. And there are two more crossings also considered as general crossing, are not negotiable crossing and account payee crossing. Carefully understand these two are general crossings. Okay. Now let us see two transverse parallel lines or face of the check if written. Which side does matter? Top button parallel lines to become considered general crossing. Okay. What is account payee crossing? This is a direction given by the drawer to the collecting bank, and the proceeds should be credited to account of the payee. Account payee check crossing statute. Without a crossing, when the check is given as account payee, check cannot be paid over the counter, because account payee means the drawer gives the instruction according to the mandate given authority to the collecting bank. The proceeds should be credited only to the account payee's account only. Okay. If the collecting bank confirms that the proceeds are credited to the payee, then the paying bank is safe to pay the collecting bank. What does it mean? If the responsibility of the collecting bank to confirm whether this check has been collected for the payee, the person who named in the check, not anybody else. Only one circumstance is permitted to collect the checks for other than the payee. That is, the drawer. The drawer has written the check saying account payee, and given the check is given in the favor of, you say, Chandra Stores. Now, Chandra Stores, the proprietor is the Chandrapala. Chandrapal is having an account at the bank, whereas he does not maintain an account for the business. Now, Chandrapal can ask the bank to collect this check. Although the account is not account pay only, that will be going to his account and cannot be cash over the counter. Okay, so Chandrapala, if he deposits his account, there won't be a problem. But now Chandrapala is depositing to Chandrapala's account, they are checked in row in favor of Chandra stores. So the payee is different now. If the collecting bank confirms that the proceeds are going to the same person that put it under sole proprietorship, same person, then with the accepting the guarantee, paying bank can honor the check, right? Honor the check, and necessarily can be routed through the system to the Chandra source account. Right? This is only one incident where we can see that if although the check drawn in favor of a payee, it can be collected for some other account of the payee if the bank is satisfied about that. For that matter, bank has have to give a guarantee to the paying banker. Right? On the reverse of the check, the bank has to certify fate of proceed certified. Fate of proceed certified. That means bank is giving a guarantee the fate of proceed of the check will be going to the same person. And the Chandra stores or Chandrapala is the same. But it cannot be collected for sole partnership or a company. Let's keep in mind that also. If the collecting bank collects check the proceeds to another account instead of the payee stated in the check, that could be held negligent. Right? Right. Next comes not negotiable crossing. This is how to be carefully understand this not negotiable crossing. Bearer shall not have and shall not be capable of giving a better title to the check that which the person from whom it has took. Section 81 of the Military Exchange Ordinance deal with the negotiable crossing. These crossings are general crossing. So the only instruction given for the collecting banker. Right? Bearer shall not have capable of giving a better title to the check than it was person from whom he took it. Internally, we are telling that if the check is collected for a third party, then the bank is liable. If it collected to the same, name appearing in the check, then there won't be any issue. It has to be certified by the bank. Fate of proceed guaranteed. So the paying banker will, without any referring to anywhere, he will honor the check. Okay. Check is negotiated when it is transferred from one person to another in such manner as to constitute the transferee of the holder of the check. Right? Check negotiated when transferred from one person to another in such a manner, according to the regulation, as to constitute the transferee, the holder of the check. The transferee is the holder of the check. Okay. So when check is negotiated, there are two types of checks are there. One is called bearer check, other one is order check. Very commonly used is the bearer check. A bill payable to a bearer is transferred by delivery. A bill payable to a bearer is transferred by delivery. That means if the check, open check or account payable check, if it's a bearer check, transferred by delivery. Just handing over, check can be transferred. Any check, for that matter, can be transferred by delivery. That means it's handed over, the check's ownership will be transferred. Section 81 of the Bill of Exchange Ordinance. There are checks we described, which I showed some check. It's order. Sometimes it can be printed order, or when the drawer or any party holds the check can convert the check into a bearer check into an order check. Just writing a strike over the bearer is becoming an order check. Right? A bill payable to order negotiation is by endorsement of the holder completed by delivery. Not only the delivery, it has to be endorsed and given. Right? All order checks when endorsed and transferred becoming a bearer check. Thereafter, it becoming a bearer check. Only to the payee only, it is going to be a order check. Anyone else comes forward, it is anybody comes forward for check, it is going to be a just to transfer this order. Order check where it has to be negotiated with an endorsement. That means writing the name as a pay in the front on the reverse of the check will be becoming the mode of transfer. Section 31 of the Bill of Exchange Ordinance. So with a bearer check, just delivery, just giving hand to hand can be transferred. Order checks, it has to be endorsed and handed over by delivery. All order checks when endorsed and transferred become a bearer, right? First transaction of the order checks when endorsed and transferred, thereafter it become a bearer check. It can be negotiated just by delivery. Right? So therefore, negotiable instrument may be negotiated two ways: by endorsement and delivery, instrument drawn to order; by delivery, instrument drawn to the bearer. Right? Now let's see what's the other crossing. Special crossing, where a check wears across its face an addition of the name of the bank with or without word not negotiable. A check can be drawn by anybody who is holding check can convert a check to a special crossing. Where two transfers parallel lines, in between the lines, to write down the name of a bank, it's becoming special crossing. Or else, for that matter, the face of the check, wherever write the name of a bank, then it's becoming a special crossing. Right? Most of the participants misunderstand this. For a special crossing, there should be bank's name written in between or not, becoming a special crossing. That addition constitutes a crossing, and the check is first specially to that bank. So it can be banker can become a payment can be given to the banker for collection, and then in turn that money will be deposited to the depositor. Right? Drawing special crossing is drawing two parallel lines with the name of a banker on the face of the check is called special crossing. Crossing stamp placed by the banker is not a special crossing. Earlier, before this truncation system was introduced, banks were placing the crossing stamp on the face of the check. But now it is not there. It has to be placed on the reverse of the check to identify which bank has collected the check. Okay? To identify the bank who has collected the check, the endorsement is required. Crossing stamp placed by the bank is already special crossing. Writing name of a bank is considered as a special crossing. bank's name as a payee is not a special crossing. You have to identify the difference between the special crossing, where the name of a bank is incorporated, so that bank only can collect that check. Right? So, when those days, the bank used to place the crossing stamp and doing a clearing. Now it is no more there. The bank has to place the crossing on the reverse. Therefore, that bank crossing is not becoming a statutory feature. Okay. When the payee's name is a bank, it is not a special crossing. Okay. So we have a comparison between general crossing and special crossing. Drawing two parallel lines, transit lines a must for general crossing. Those lines are not necessary for special crossing. Inclusion of the name of the banker is not essential in the general crossing. Inclusion of the name of the banker is essential. Right? That's a compulsory for special crossing. In general crossing, paying banker to honor the check from any bank account. Now, for example, a crossing stamp is placed, or a crossing right written by the drawer or the bearer on the cross of the check, a bank's name. That check can be only deposited to that particular bank, or collected by only that particular bank. Now, for example, say NDB Bank. Cross for NDB Bank. So any branch of the NDB Bank can collect that check. Any branch of the NDB Bank can collect that check. If the NDB Bank Kolpiti branch, then only Kolpiti branch can collect that check, nobody else. The restrictions can be placed to overcome fraudulent transaction, to avoid that type of transaction. So the bank will use this crossing stamp to protect the customers. Okay. Inclusion of the bank name is essential. In special crossing, paying bank to honor the check only when it is presented through the bank mentioned in the crossing and no other bank. Right? So the collection should be only from the bank named in the check. General crossing can be converted into a special crossing. Special crossing can never be converted to a general crossing. It can't be converted into a general crossing. In case of general crossing, the words and company or not negotiable between two transverse parallel lines highlight a crossing does not carry special significance. Because a customer crossing the not negotiable to control the what you call legal position. See, not negotiable. So let us talk about boarding. Not negotiable. And we will come to that later. In the case of special crossing, the name of the bank may be written between the two parallel transverse lines and word and company account pay or not negotiable. Inclusion is customary. Okay. Cancellation of a crossing. General crossing by the drawer can cancel crossing. But a special crossing by the bank whose name appearing within the crossing has to cancel the crossing. If it's NDB Bank, any branch of NDB Bank can cancel the crossing. But if it's NDB Bank Kolpiti, only NDB Bank Kolpiti can cancel that crossing. Okay. Right. Before we go to legal protection, let's see about this negotiable, not negotiable crossing. Right? What is the impact of this not negotiable crossing? Okay, I'm going to the whiteboard. See whether you can see this. In the negotiation we discussed earlier that A gives the checks to B and C stores the check from B and given to D. Okay? The normal circumstances we discussed earlier that D is getting a better title than C. D is getting a better title on his check than C. Although it's a stolen check. Okay? When this check written, it is crossed, not negotiable. The negotiability, transferability is not affected. The negotiability will be affected. Okay? Now this check, A is given the check to B, C steals the check from B and given to D. So D is not getting a better title than C. Okay, C is having a tainted title, therefore D also getting a tainted title. He does get a better title than. So the not negotiable crossing is important to any fraudulent transactions. For the time of the fraudulent transaction taken place, the ownership will not transfer in a proper way. Ownership will not transfer in a proper way. That's why the not negotiable crossing is impact on not negotiable crossing. Okay, so normal circumstances without not negotiable crossing, it is a general crossing without the word not negotiable. D is getting a better title than C, but when you put not negotiable crossing, D is not getting a better title than C, or C is having a tainted title. From here onward, the ownership, the title is tainted. So that's about importance of the not negotiable crossing. Okay. Right. Let's get back to the crossings. So therefore, under section 81 of Bill of Exchange Ordinance, bearer shall not have and shall not be capable of giving a better title to the check than which the person from whom he took it had. That's the impact of the not negotiable crossing. Okay. So to negotiate, if you process the bearer check, it can be negotiated by just delivery. All the checks has to be negotiated with the endorsement. So we'll discuss what is endorsement later see. Okay. Right, we were here. Now let us see what are the legal protection given for the collecting bank. Legal protection having collecting bank. First one is section 82 of Bill of Exchange Ordinance. Then there's a principle called defense of estoppels and also contributor negligence. Now these are the instances where the collecting banker is protected. Okay, why is protection needed? Collecting banker is responsible for true owner of the check when collecting checks. True owner. Okay. Let's see what is section 82 Bill of Exchange Ordinance says. Where a banker in good faith, number one, what is highlighted, very important four cases, and without negligence, received a payment For a customer of a check crossed, generally or specially, to himself, and the customer has no title to the or defective title thereto, the bank shall not incur any liability to the true owner of the check by reason only of having received such payment. The banker received payment of a cross check for a customer within the meaning of this section, notwithstanding that the credits to his customer's account with the amount of the check before receiving payment thereof. Even the check is purchased, paying bank is not the collecting bank is not liable for the true owner if the true owner acted these four important conditions. What is in good faith? Paying bank, the collecting bank should act in good faith. In good faith means, right, without any bias, without bias to the customer. Can you give an example? Now, what is the time of closing the bank? We say 3 o'clock. We are 3 o'clock, our banks are closing. Now, one of the customers, friend of some of the bankers, may come to the bank after closing the bank and ask him to collect the check. If the bank accepts that check collection, right, that transaction is not done in good faith. The transaction is not done in good faith. If a collected later, it is not in good faith. Similarly, now present banking system, what do you call activities, the checks are deposited in a deposit box. It is the duty of the collecting bank to collect checks at 3 o'clock in this cut-off time, not before or not after that. If any customer comes and deposits a check after 3 o'clock into the box, then the banker goes lately about 3:30, 4 o'clock and collect those checks and collected, he has not acted in good faith. He tried to help his customer, it's not good faith. So it has to be within the banking practice, it has to be done. Then without negligence, this is another very important part. What is negligence? But without, what is negligence? That is, the banker does the work not according to the practices and the laws and rules. Without negligence. That is where they see the word there. Without negligence. Negligence is also a negative term. Negligence is a negative term. Without negligence means under the good term. It's a further negative. Okay, see the word very, very seriously put the word across there. Now, for example, this is very practically what's happened in most of the banks. Now, today, today, 20th of March. Okay, we consider today is a working day. Consider it is a working day. Now, a customer brings a check dated 21st of March. Customer brings a check 21st of March and deposit that check to his account today at your bank. Okay. 20th you collect the check because customer thinks that the check is going to the paying bank on 21st. So the check date is 21st. Okay. There won't be any problem. Even banker, you collect the check on 20th. On the date of the check 21st, although you collect the check and send it for clearing collecting bank, paying bank. Paying bank have two options, either pay the check or return the check. If paying bank pays the check, paying bank is responsible for negligence. If you return the check, collecting bank is responsible for collecting that check. Why is that? Why is that? You cannot collect. Now, I'll come to this way, I'll put up first. Now you collect this check on 20th, later 21st, and you are doing a scanning the check. Now the physical check is not moving. Those days physical check is moving. Therefore, even you collect 21st check, doesn't matter. Physical check appears in they are at the paying bank on 21st following day. But when you are sending an image of the check today, you take the image, scanning the image, and transmit the image to the paying bank, to the clearing system. When you take the image of the check or the reverse of the check, date and time of the receiving that, the scanning time is printing on the reverse of the check. So what date it has printed on the reverse? Is 20th. Face of the check is 21st. Therefore, you have collected the post-dated check. Now you are negligence collecting a post-dated check. Okay. Negligence for collecting a post-dated check. On the other hand, paying bank, if you pay for this check and return the customer's genuine checks, then paying bank also responsible for the customer for what you call improper dishonor. Right? So dishonoring check, wrongful dishonor of the check. We'll discuss a little later what the repercussion of wrongful discard. So both the banks are negligence. You are collecting, you are negligent, collecting banker, paying banker by paying that check, negligent. According to the present clearing system, paying banker will not receive checks on the same date. Same date check क्या खादात इन्हें नहीं paying banker given the clearing system में. Of course, counter deposit कराना, what the counter नहीं transfer, yeah, okay, can, but not a collection check. Okay, right. That's the second condition. In good faith, without negligence. Third condition, for a customer, collect a check for a customer. Who is this customer? Who is this customer? In the morning we discuss. Who is a customer? Customer is a person who is having a current account. Customer is a person who is having a current account. So you have to collect a check for a customer. You have to collect a check for a customer. It's a current account holder. If you collect check for a savings account holder, you are not getting the protection on the bill of section or 8-year-old bill of section. If it is a fraudulent check, you are not getting the protection. Okay. Right. So, there was a lady, old lady, going to given a developer lottery ticket to her daughter. She's a teacher. Asking, do you balaba maker monarchy or the just give the ticket to the lady, old lady given to the teacher, their daughter, to see if there anything there in the drawing. She said, Ali Naami, put the ticket on the table and went off. 2-3 days later, the old lady is watching the TV news. She has seen the daughter has gone and collected 1 million check from the developer lottery. She is collecting 1 million check from the developer notice. She saw in the news item. So immediately she went and searched for the ticket. She found the ticket was not there. And now she is suspicion. The daughter has taken the ticket and obtained the money. Okay. Following the morning, she went to the police and lodged a complaint that daughter had stolen the developer ticket and taken the money for that. And therefore, police intervene and get the money to her because that is her money. Ticket is owned by the. Now this lady brings the checks to the bank and depositing to the savings account or a current account for that. What's the position of you? If you collect that check, you are not protected under bill of exchange ordinance. Why? Savings account customer is not considered as a customer for collection of checks. A number of legal issues there. Next session I'll try to discuss with that. Okay, so these are the instances, like examples for us to understand the gravity of it. Then it should be a cross-check. It should be a cross-check. Without cross, with the crossing is not an open check. So again, you are not getting the protection of the bill of exchange ordinance to collect the fraudulent check. Okay, so these are the important factors. Understand when you're collecting checks, the legal requirements are there. So we have to look into those legal requirements. Why, when a check is deposited in the savings account, you ask the A-class officer or a manager to sign that? Because to take the responsibility of collecting the check, there's no fraudulent bona fide of the check has to be established. Okay. Then collecting the role of collecting a check is called agency law. And duty and responsibilities of collecting check we discussed. Collecting banker's responsibility and the duties. And responsibility towards the customer, to the collector, to the true owner. Now, there are certain instances where in practice we collect the checks for not for the owner. I told you the example. If you collect the check for what you call sales rep. Sales rep, they open account in their name and deposit principal's checks into their account. If any fraudulent checks has been deposited and collected, so you are liable to the true owner, that is the principal, or the principal is liable. Bank is liable for that. Right. A customer is entitled to stop payment of a check that has issued before bank pays it. Before the bank payment, a check can be stopped. The drawing of a check and stopping of a check are both instructions to a banker that must be not disregarded. Section 87 of the Bill of Exchange Ordinance. The customer's instruction to stop payment should be clear, unambiguous, unequivocal, and unmistakable. It should be in writing, signed by the customer, giving the check number, date, and the amount and name of the payee. Specifically should give the check can be stopped. Even a payment can be stopped by any person who is having the check. Payment in due course, we say. Hold of due course, that any person holding a check at a given time, when he lost the check, he can inform the bank not to pay that check. Okay, so the payment can be stopped by the paying bank. Right, what are the materials for the payment of checks? Let's see. What are the information needed? What are things needed to for as a paying bank? Right. Legal relationship for a paying banker is the contract does it with the customer, drawer. Pay according to the mandate, the authority. He said it's a contract. Mandate is a contract. Impact of the Bill of Exchange Ordinance, protection given to the paying banker under Section 60 of the Bill of Exchange Ordinance. So the paying bankers are protected paying a check under Section 60 of the Bill of Exchange Ordinance. What is Section 60 of Bill of Exchange Ordinance? When a bill payable to order on demand is drawn on a banker, and the bank on whom it is drawn pays the bill in good faith in the ordinary course of business. Only two things. In good faith and in the ordinary course of business, it is not incumbent on the banker to show that the endorsement of the payee or any subsequent endorsement was made by or under the authority of the person whose endorsement it purports to be, and the bank is deemed to have paid the bill in due course, although such endorsement has been forged or made without authority. Now here talking about the endorsement, right? When you're talking about endorsement, it should be a order check. Should be order check. The order checks only with the endorsement counts. Bearer checks also, where if the check is paid good faith in the ordinary course of the business, right? Bank is protected. What is this ordinary course of business? We'll take a small case. One of your customers brings a check after closing the bank. That's after 3 o'clock. He say it's about 4 o'clock. 4 o'clock he brings a check to deposit to his account. Okay. And it's a transfer check. It's the same bank check. So it will not one thing that will be an effect. Because you own the same bank check, customer boards, and the drawer also issues the check for the same bank. So same bank, drawer, and the depositor both are the same bank. Right. So he brings the check at 4 o'clock and asks him to deposit to the account. You collect this check and pays. Is it just a transfer? Transfer money to the customer. And following day, there's another check comes from that particular account and you return that check because funds are not sufficient. So the drawer can sue you for not acting according to the Act, Section 60. Because you are not collected the check, paid the check in ordinary course of business. He has records that he issued this check at 2:45 or 3 o'clock. Just about 3 o'clock he issued this check. He has a record to prove that this check should not be able to go to bank because it is issued after the closing of the bank. And if you try to help a customer, then you are liable for, you are not given the protection. So it can be, the customer can sue you for the damages. Customer can sue you for the damages. This is what the under Section 60 Bill of Exchange orders, the protection for the paying bankers. Okay, Section 80 of the Bill of Exchange orders also have the protection for the paying banker, where the banker on whom the cross check is drawn in good faith and without negligence pays it. If crossed generally to banker itself, and if crossed specially to the banker to whom it crossed, or his agent for collecting, being a banker, the bank paying the check, and if the check has come into the hands of the payee, the drawer shall respectively be entitled to the rights and be placed in the same position of as if payment of the check has been made to the true owner thereof. Negative, right? If you're paying a check under Section 80, it is a cross check, generally or specially, or collected to the collection payment made to the collecting banker within good faith and without negligence. Yes, is deemed to be paid to the true owner. Right. So that's what, that's all about the protection for collecting banker. Now let's one of the important things the paying banker is looking for is the endorsement. What is this endorsement? The word endorsement is said to have been derived from the Latin en means upon and dorsum means the back. Thus usually the endorsement is on the back of the instrument, though it may be even on the face of it. Where no space is left on the instrument, the endorsement may be made on a slip of paper attached to it. So the endorsement, any number of endorsement can be placed. That's what it says. And what is the mean by endorsement? Now, endorsement needed under Section 31 of the Bill of Exchange Ordinance for order checks. Right? If it's a bearer check, if this bearer is cut, it's becoming order check. But order check cannot be converted into a bearer check. Bearer check can be converted into order check. Anybody can convert bearer check into order check. Okay. On the reverse of the check, there are two components. These are for the endorsements. Left hand side. Right hand side for the banker to make bank's endorsements. What are these endorsements? Right? What are these endorsements? Writing the name as appearing in the front of the check. Writing the name as appearing in the front of the check. So the endorsements are, it's not a signature. Writing the name as it is. So when you try to endorsement, there are a number of, when the paying bank is looking into a number of things. Number one is, it should be in the flowing handwriting. It should be in the flowing handwriting. If the endorsement is the capital letters, that endorsement is not accepted. It's called endorsement irregular. If the paying bank has written the check, endorsement is irregular. If the endorsement is not clearly written, can return as endorsement eligible. When the endorsement is in two different language, that also can be rejected, not accepted. The language is not material for endorsement. In the face of the check, it is in singular, but endorsement can be either singular, Tamil or English, any language. But that parameter should be completed. Okay, that requirements have to be completed. Whenever endorsement is there, endorsement now, according to the new clearing system introduced in 2005, checking the endorsement is a collecting banker's responsibility, not the paying banker. Checking the endorsement is a collecting banker's responsibility. So the collecting bank has to certify the endorsement. If the endorsement is placed eligible lawyer, some sort of endorsement has to be certified by the collecting banker. That is endorsement guaranteed. Place to pay is credit. Payment, if you can't pay a check, place to pay is credit. Pays account will be credited on realization. A number of other stamps available in the bank. And use the collecting bank has to certify the endorsement. That's a required requirement. Okay. Right. Parties to whom the paying bank is responsible to the customer to pay the check on demand if it's in order. If it's in demand means if it's on the due date. That means if a post-dated check is not becoming a on demand. It is within the 6 months, and percent of a payment checks is drawn within 6 months, is check in order. Otherwise, the check is not in order. It should not be stale. That means after 6 months, check is stale. When the validity expired, then within the validity period should be submitted. On demand, properly drawn and presented. Check has to be completed in all statutory requirements. Date, payee, if the payee is not there, it's a cash. If it's a cash check, it should not be, it should be a bearer check, it cannot be a porter check, right? And presented to the clearing system correctly, collected by the clearing system, that has to be there. The sufficient funds available or any other arrangement. This is very, very important to understand the legal requirement. According to the Great Western Railway Company case, they decided funds should be available to pay the full value of the check. Great Western Railway Company case, it was decided by the judges that funds should be available to pay the full value of the check, not a part. Or funds are not available, then the customer has to make arrangement in advance, not after the check is presented for payment. This is legal system requirement. But today what's happening in the practice? Funds are not available and bankers are waiting the customer comes and deposit the money. Completely violating the regulations. You can't wait till the customer to deposit the money because check has to be paid on demand at the time of presenting to the Lanka Clear, and it is processed at midnight, 12 o'clock. So when the day starts at 12 o'clock, funds should be available. Or if customer wants some order facility, that has to be fed into the system. Fed into system, thereby when the check is presented to payment, system will automatically pay the facility check. That's a requirement. Any legal obstacles for payment? When the signature is okay, the signature is completed. There can be some business organizations with the signature. The rubber stamp is also part of the signature. And also on the face of its check has to be any other material should not be there in the face of the check. Legal obstacles are there. And what are some of the legal obstacles? Amount and figure and the words are differs. Check post-dated checks or validity expired checks, stale checks. Endorsement is not there, or endorsement is not correctly done. Those are legal obstacles for payment. So, paying bank is liable to pay a check within this framework. To the true owner of the check, the value of the check to be paid to the true owner. Check who have the paying banker's responsibility to pay the check to the true owner. That which comes to the clearing and is expect the collecting banker the responsibility to find who is the true owner. To the collecting bank is mainly concerned with the rules of the clearing system and the doctrine of recovery of money paid in mistake. What is doctrine of money paid by mistake? Collecting bank are responsible to collect funds on behalf of a customer and credit the same to that account. If the collecting bank collect the check and deposit the money to some other account, then the collecting bank Penalty bank is responsible for the customer. Okay. So the doctrine of recovery of money paid in by mistake means if you are credited to a wrong account, you have no authority to debit that account. There are decided legal cases are there. You have no authority to debit the customer and get the money. Without customer consent, you can't recover that money. That's called doctrine of recovery of money paid by mistake. Okay. Right. Now comes to the check returns, the wrongful dishonor of a check. The wrongful dishonor occurs when a bank declines of a payment of a check without a valid reason. If the paying bank returns a check without a valid reason, then paying bank is responsible. When a stop payment order has been withdrawn by the customer places a stop payment order to feed into the system. But later he comes and withdraws that stop payment order, but you have not removed that from the system. So when the check is presented for payment, it will automatically return saying this payment stop by over. You are liable for that. It's a wrongful dishonor. So any damages, you are responsible. Returning a check issued by the customer for insufficient funds due to payment of post-dated checks or payment stop checks. Now the payment stop checks are no more notice in practice coming up, except for stop payments has not been fed into the system before the check is paid present. The duty of the banks to, whenever stop letter comes to make a stop payment, immediately it has to be fed into the system. If you have postponed it by that time, the intervening time, if the checks has become for payment, then paying bank is responsible for wrongful dishonor. And also, the payment of postage check, I just gave you the example earlier. It's a very common factor, payment of postage checks. Not making an overdraft facility already sanctioned. House versus Bedford Banking Company, 1894. All the overdraft was given to the customer. It has not been recorded in the ledger system and customer issued. Now today, this is 1894 case. But today this is very, very serious. Why? One bank. This is one bank, not branches. So that check can be presented for any branch of that bank. Last week we discussed this unit bank and the banking system. So any bank, that check can be made available for person for payment. So in such instances, funds are not available, the check is not returned by that particular branch, not from the bank where branch where the customer may maintain the account, then bank will find liability. Okay, wrongful discharge of a check. When wrongful discharge of a check, bank is liable for two major issues. One is breach of contract, other one is called libel. The paying bank breach is wrongful dishonor, that is returning a check without a valid reason, incorrectly. Paying bank is liable for two things. One is breach of contract, other one is libel. Breach of contract means the bank has acted violating the mandate of the customer. Violating the mandate of the customer. That's called breach of contract. So if you return a check, right, the value of the check and the position of the customer is very important. You may return a check, but due to the return, right, the customer had not had any big loss. Check has been returned, but there's no big loss or any happened to the customer. Then file action, court may decide to give a nominal damages. If there was a case, only £1 were asked to pay, only £1, because it's established the bank was liable for breach of contract. But the damages were could not prove by the customer, therefore only gave the nominal sum. But if it is proved that customer suffered loss due to these damages, if the customer has lost the business or lost the contract or other penalties has been imposed on him by the payee of the check, then the damages will be very high, depending on the customers, the value of the loss as well as his damages to his damages to him and his credibility. So there are serious damages are defamation. Defamation is one of the serious damage. Okay, so we have to be very careful while you returning checks. The other one is libel. Libel consists of a publication to a third party of an untrue imputation against the reputation of another, ordinary in writing. Refer to draw consists of libel on its customer's reputation. Jason versus Wittenberg, 1968. This case, Jason Midland, the Midland Bank has written a check asking refer to drawer, but funds are available. Now, normally we return check refer to drawer when the funds are not available. But Midland Bank wrote this remark, customer to come and see the bank, right? Refer to drawer, refer to the drawer this check, and it has some misunderstanding of something about the payment of the check. So it is considered as a defamation under this case. Yes, our Midland Bank case it is the customer's reputation has been damaged, so the bank was liable. Okay, so for a third party or somebody, publication tell something bad about a customer or returning a check, does remarks which is not applicable to the case, you are liable. Now you cannot place check return remarks by your own. You have to follow the Lanka Clear, the list of check return, what you call remarks have been given. Other than that, you can't use any other remarks. If you use any other remarks, the collecting bank can reject that, accepting that check return. So wrongful discharge is a very serious one. The matters obliging the bank not to pay a check, notice of countermand by its customer, stop payment, you can stop. Notice of a death of a customer, section 75 bill of orders. Notice of the death of a customer. Death of a customer, death of a partner, right? Death of a joint account holder, you have to stop the payment. But death of a director, death of a partnership partner will not affect the payment of the check. payment are not effective because of particular customer's death. Okay, notice of mental incapacity of the customer. That is, if you come across the customer's mental incapacity, then check can be, you can stop making, you cannot pay the check. Right? Notice of bankruptcy, customer, one of the joint account holders. If you look at the newspaper, you may find one of the customer or company may declare, given by the court order, that that company is bankrupted. So once it's bankrupted, no contractual capacity has to stop. You have to return the checks. Notice of winding up petition against the company. Right? So under Section 7 of the Companies Act, notice is published that company is going to wind up, that account, checks on that account you cannot pay. Servicing a garnishee on the bank. The garnishee order is issued when the funds are blocked. Even the funds are available, funds are blocked, you can return a check. Servicing an injunction order by a court of law. Right? Funds are available, again, funds are held against the injunction order. So you cannot pay a check. Serving an order by Inland Revenue Department. Section 27 of the Inland Revenue Act No. 16 of 1985. So you may not pay the check. Closure of the customer's account and not to pay a check. Right. So that's all about the negotiable instruments, collecting and paying bankers' responsibility. Okay. So we'll have a small break and come back and continue with the opening of accounts. Actually, then first opening of account, then we should have gone for this. Anyway, doesn't matter. Okay, let's start session. Actually, this should have been done earlier, but anyway, doesn't matter. Different type of deposits accounts. What are the types of accounts they are having, and how to open accounts? What are the requirements? The current changes. Let's see what are these things. Types of accounts we are having: demand deposits or the current accounts, savings deposits, and term deposits, foreign currency deposits. These are types of deposit. We all call these as liability products. Liability products in the business. Institution authorized by the Central Bank of Sri Lanka to take deposits from the public. According to the Central Bank directives, only certain categories of institutions are legally authorized to accept deposits of money on the public. So not everybody cannot collect funds on the public, and certain authorized persons, authorized companies are only allowed to collect funds. Institution authorized by Central Bank Sri Lanka to take deposits from the public, licensed commercial banks, licensed specialized banks, and registered finance companies have been given authority by the Central Bank of Sri Lanka to mobilize deposits from the public under the existing laws. So, one of the institutions not here, no? Have you noticed? Licensed commercial banks, specialized banks, registered finance companies. What about the leasing companies? According to Central Bank directive, leasing companies cannot mobilize deposits. So that's why almost all the leasing companies are attached to a finance company or a bank. Right? So this is leasing companies are not legally authorized to collect funds directly from the customers. However, cooperative societies registered in the Cooperative Society Law No. 5 of 1972 and building societies incorporated under the National Housing Act have been exempted from the requirement to obtain license from or to register with Central Bank for purpose of taking deposits. So exempted to organizations are cooperative societies, that is cooperative rural banks. They are coming under Cooperative Development Act, and also National Housing and National Housing Act. What do you call? They are also authorized mobilized deposits under housing, what do you call, housing funds. Okay, and furthermore, any legitimate non-profit oriented organization can accept deposits, but only from its members, and that too with the written permission of the Monetary Board of the Central Bank of Sri Lanka. Legitimate non-profit oriented organization can accept deposits, but that also has to obtain by the Central Bank permission. So benevolent funds, you find trust, the provident fund, pension fund, or some of these funds which is to be approved by the Central Bank. Yeah, funds can be collected from the public. Right. Bank Act number 30 of 1988, as amended by Bank Act 2 of 2005, has given a definition of deposit as given below. What is a deposit? Deposit includes a sum of money accepted from any person as a business on terms under which it will be repaid with or without interest or a premium, and either on demand or at a future time in circumstances agreed to by or on behalf of the person making the payment and the person accepting it, provided that persons accepting the money is a person who is in usual course of business, lends money or makes available use or the benefit of the money so accepted third parties or includes any sum of money accepted. So what is deposits? Includes some money accepted from person or as a business, called deposits. Okay, so opening of accounts, basically what are the requirements? Any person over 18 years, because minors can't open account because there's no contractual capacity. Then majors, whoever over 18 called majors, a group of persons, and there are certain majors are there, not by the age, by certain other legal requirements. Group of persons, organization, and some disabled persons, how to open account, and business entities. Right? Right. Let's see what are the eligibility criteria for open an account in the bank. Any person over 18 years can open account because according to the law of Majority Act, Sri Lanka, over 18 persons are considered as majors, elders. They are entitled. So there's no what do you call upper limit for opening of accounts. Any person over 18, the upper limit is not there. Anybody, right? Then group of persons joint accounts can be operated, and organizations. We'll discuss later what are these organizations, and also disabled person also eligible to open account. Right? Disabled mean physically disabled and physically disabled or audio visually disabled. There are certain other categories are there. They also entitled to open account. But there are certain people who have been not business entities, not eligible to open accounts. Who are they? That's not legally contractual capacity not there. Who are they? Yeah, below 18 years, minus, according to the law, they have no contractual capacity. They can open accounts. Then, yeah, mentally incapacity. People who have been not in mentally sound mood, they can't open accounts. Or they don't have contractual capacity. And there are certain categories are there temporary mental disorganized people, drunken people. Well, yeah, they are in that situation. We can't open account because there's no intellectual capacity is not there. Then bankrupted people who have been bankrupted, those the court has been issued orders that any person's liabilities are more than his asset, court can decide that he is bankrupted. So bankrupted people also does not have a legal eligibility to open account. Right. Other than that, anybody else, everybody can open accounts. Right. What are the legal requirements to open account? There are certain personal laws in Sri Lanka have an impact on opening of the contract. So the law of contract. What is the impact of Tesawalame law? What is the impact of Muslim Sharia law and the Canadian law? Right. Tesawalame law is applicable to only one area. Before we talk about personal laws, the applicability of the personal laws are to the three areas. That is marriages, divorces, and property inheritance. These are three areas where the Tesawalame law is being affected. Sorry, any personal law will be affected. Under Tesawalame law is applicable for the permanent residents and rooted in Jaffna Peninsula. That area only this Tesawalame law is applicable. They call Malabas. It's applicable. So therefore, outside the Jaffna Peninsula, this law will not be applicable. Only Jaffna Peninsula. Not all the travels are affected by Tesawalame law. Only the certain period. That means Eastern Province and upcountry travels are not coming under Tesawalame law. What is the impact of Tesawalame law for us is the married women cannot get into a contract, any contract for that matter, without husband's written consent. Married women cannot get into contract without husband's written consent. This is the law. Therefore, whenever a lady, a Tamil lady comes for an open up account, we have to verify whether she is coming under Tesawalame law or not. If she is coming under Tesawalame law, then we have to take the husband's written consent. Otherwise, that contract will be legally not enforceable, null and void. Therefore, we have to verify this lady whether she is coming under Tesawalame law. Normally, you can see the national identity card, NIC, where the place of birth shows as Jaffna Peninsula. So no question, directly you can ask that requirement. But now most of the younger generation are out of the Jaffna Peninsula, living in other places, and their place of birth is given as outside the Jaffna Peninsula. So very difficult to trace because their families are, the parents, grandparents are residing in Jaffna Peninsula. So they are also coming under this category. So to overcome the situation, to protect ourselves, what we have to do is get an affidavit signed by a JP that if she is not coming under Tesawalame law, she has to declare that she is not coming under Tesawalame law, and an affidavit has to be obtained. Then we can protect ourselves from this law. Okay, so there are certain practical issues I like to raise sometimes. For example, if a husband and wife, Tamil lady and her husband, right, outside the peninsula or maybe inside the peninsula, asking for a facility for the, coming to open account. Husband and account, wife, especially joint account, open a joint account. Do we need to get a husband written consent? Do we need get a written consent? Yes. Husband and wife, that agreement is different because bank is signing an agreement, contract between two parties, two individuals, two different individuals. Both individuals should have the contractual capacity. Therefore, even husband and wife, husband written consent has to be obtained. Okay, right. Next, come to the most controversial topic of the day, Muslim Sharia law. Let us see what is the impact of Sharia law and what is the major issues in Sharia law. Now, we compare with the Sharia law, with the common law of the country. We had two types of laws, English law and common law. Under the law, common law in Sri Lanka applicable, what is the age of marriage? It is above 18. So any person married below 18 is an offense. It's a criminal offense. Right? No contractual capacity. Therefore, marrying a person below 18 legally not accepted. Legally not accepted. Therefore, under Muslim Sharia law, if a Muslim marries below 18, he or she is treated as major. He or she is treated as a major. If married, right, once he married, they are becoming majors. Right? The age is not material, or age is not matter. Under Muslim law, forget marriage. That is the present controversial issues because of that. Under Sharia law, the requirement for marriage is the becoming an adult. Is becoming adult by puberty, male or a female, becoming puberty, becoming an adult. When you become adult, they are eligible for get married. That is the Sharia law. So age is not material. Even by age of 8 or 9 or 10 or 12, a girl get puberty and she is ready to give birth to a child. Physically, she is matured. Physically, she is matured. Right? So the age law is brought by the Western countries got these laws. So we are following these Western country laws. Therefore, we are always seeing this as an issue. Right. Then the second issue comes in the Muslim Sharia law is how many marriages can done? Normally, if in a general, in normal course of the normal law, you can marry only one. If you marry more than one, that subsequent marriages are illegal. Multi-marriages are illegal. So it is again criminal offense. It's a criminal offense. But under Muslim Sharia law, you can marry up to 11 because the Prophet Muhammad they married 11 times he are married. So within that parameter can do, but there are certain conditions laid down by the Sharia law. If you are going to marry more than one, there are certain conditions you can marry. Now, what is the practical issues about these multi-marriages? There are instances where the non-Muslims also changed their name into Muslim names and they had 2-3 marriages. Muhammad Gabri Fonseca, the famous cases, Muhammad Major Vijay Vikrama, they get Muhammad name in front with Muhammad and they shows as they are Muslim and marries under Muslim Sharia law. right? So there's a case at the Supreme Court. Supreme Court, there was a case regarding this change in the religion. So this type of work, where Mr. Saratheni Silva has given the judgment before his retirement that you cannot change a religion if not practice. For that matter, any religion. For different benefits and the requirements, you may change the religion, but if you are not practicing the religion, it is illegal. So now these people, non-Muslims, can't get married under the Muslim law, Sharia law. Okay. Then comes the Candian law. Candian law also a provincial law, which is applicable to Kandy district, Kegol district, Matale district, part of Anuradhapura, part of Matale. Is the Candian territory, Candian boundaries. People who are living in that area can follow Candian law. Under Candian law, sorry, mostly marriages and property inheritance is a practice. Under Candian law, any person can get married is above 16. Under Candian law, above 16 can get married. Also, under Candian law, there are two types of marriages. That is Diga and Binna. Two types of marriages. One is Binna, the other one is Diga. Diga, where everybody mostly common one, is the where groom is the bride is coming to groom's place, residing with groom. That's called Diga, where the authorities vested in the husband, Purushadipati. On the other hand, Binna, where the husband goes to wife's house and living there with wife's family. That's called Binna Baino, the common factor. So it's called Binna. There, the authorities with the lady, wife. Then they are killing the Indona, petticoat government. Okay, these are the three personal laws in Sri Lanka, which is having different actions. So now the question comes to one law, one country, whether all these laws are going to amended or abandoned. Question is that. It's one country, one law. To whom is applied Islamic law, Muslim law, Candian law. All these are going to abolish in the country. That's the issue today. We are waiting for that because it has impact on our contract. Then the question comes about the Buddhist priest monks. Can you open an account for Buddhist monks? How the big show account is What's the law? Yes, there's an issue. If we talk about that, there's a legal issue some time back. Dhammarakkhita Thero applied for a driving license. Dhammarakkhita Thero applied for a driving license, which was rejected by the Register of Motor Vehicles. Register of Motor Vehicles rejected that application. Then Dhammarakkhita Thero filed action in the Supreme Court and challenging that decision of the RMV, Register of Motor Vehicles. And the judgment was given by the Saratheni Silva that time also controversial judgment of Jiladini. Given judgment that it is a fundamental right under section 122 of the Constitution of Sri Lanka. Sri Lanka Janraj Vyavastha 122 ඒක මූලික අයිතිවාසිකම. Therefore, Buddhist priest can issue driving license. Driving license දෙන්න පුළුවන්. So ඉස්සරහට ඉතින් අපේ තරුණ හාමුදුරුවරු ඩියෝ වල එහෙම මේ යනවා නම් මුත් කියන්න එපා මොකද නීතියෙන් අවසර දීලා තියෙන්නේ. ප්‍රශ්න දින හෙල්මට් එක අඳිනවද නැති කියන එක. Okay. Now the problem is because this is open. So if you're taking that judgment into the consideration, you can't deny opening of an account. You cannot say no. So we have to accept. But there are certain legal repercussions are there. We should know that when you open an account and making an account for a Buddhist priest. Right. Buddhist priest properties are governed by Buddhist Temperate Ordinance. Both the Viharaha Devala Kampanada. Buddhist Temperate Ordinance is the legal piece to look into the properties of the Buddhist priest. Accordingly, we have two types of properties. One is personal property for Paraveni Deepala and Sanghiya Deepala, which is temple properties. Temple properties are called Sanghiya Deepala. Personal properties are called Paraveni Deepala. Right? These two types of properties are there. So, accordingly, you can open an account. Now, we'll take the Sanghiya, first take the Sanghiya property. Who is the authority for Sanghiya property? In other words, who is the authority for temple properties? Who is the authority for temple properties? Is the Dayaka Sabha, Mahanayaka Hamdru, Buddha Komasaris? None of them. According to section 15 of the Buddhist Temperate Ordinance, all the properties of the temples are coming under public trustee. Coming under public trustee. Mahabharakariyata තමයි ඉන්නේ. According to the Buddhist Temperate Ordinance, no transaction can be carried out, either buying rent, leasing out, selling, everything is prohibited and should get the approval of the public trustee. Even any property has been misused, public trustee has the authority to revest those things without any compensation, according to the Buddhist Temperate Ordinance. Now, this is the problem we are having. If a Buddhist priest open an account, we may accept only personal income generated from the personal property or his personal income. Personal income is if he's doing employment, like teachers are there are Ayurvedic doctors are there, astrologists are there. So he earns, Buddhist priest earns money from their personal wealth that can be used to open an account. Right? In addition to that, Paraveni Deepala, that is the inherited properties, the income from that can be used for opening of accounts and maintenance of account. But you cannot take anything from the temple property. Pathya pol kadala ira sali account එකට දාන්න බෑ. බණමඩුව ටියුෂන් කාරට හුලියට දීලා සල්ලි මේ account එකට දාන්න බෑ. If you put it that, it is Sanghiya. So we have to be very careful about that. We'll verify that this is not Sanghiya when it comes to deposits. Next issue comes if the Buddhist priest dies. Apatut, Deepala වලට මොකද වෙන්නේ? Apatut, Deepala වලට වෙන්නේ දේ තමයි if it is personal properties except for Paraveni Deepala, inherited properties. Paraveni Deepala will go back to the what do you call their priest kith and kin, or we call as inheritors, again granted, right? All other personal income, all other things are becoming Sangika thereafter. The account is a Sangika at was. Pasti the Levi, loan a Dunda, the Plasti. Okay, so this is the background. So you can open account, but you cannot use temple property income for make deposits. It is legally not authorized. Well, can Buddhist priests open a joint account? Can a Buddhist priest open a joint account? With a layman or with another priest? According to Buddhist temperance ordinance, they can't open joint accounts because after death of the priest, the money in the accounts is becoming Sanghi. So you cannot assign that to anybody else. And also now earlier we allowed Buddhist priests to nominate somebody for his properties, but now after this case, now it is not allowed. So these are the practical issues in opening accounts. We should know what are the things legal, what are legal background, and what are the requirements to open account for different categories. Now there's another category of priests emerging in the recent past. That is Mehini Sasana. The Mehini Mahasela is what is the position? It is nowhere in the legal, there's no legal background for that. So we had to apply the common law. We had to apply common law. There are certain cases from the banks consulted me regarding this matter, specifically for NSP. They have some problems with this. Mehini Mahasi, so there's no issue about this not coverage from the Buddhist temperance ordinance. So only thing is, if such instances, we have to get the what you call directives from the Commission of Buddhist Affairs. Right? Till the laws are implemented, the general law has to be applied. Okay, right. Now comes to opening of accounts. Opening of account specifically, I'm starting with opening of current accounts. Yes, opening of current accounts. First, before opening of account, we should have an interview with the prospective customer. Why? Why is that? Current account, there are certain basic requirements are there, legal requirements are there. Purpose of opening the account has to be verified very carefully. These are central bank guidelines. Before opening an account, current account, purpose of opening, we have to interview and find out. We have to satisfy that a customer opening a current account for a genuine purpose. Earlier, when your checks comes received, to clear the checks, we open the current accounts. Now it is not needed, even for savings account. We can collect checks with the very certain verifications. You will find only Section 82 of Bill of Exchange Ordinance covering that. So with the protection, we may go for without opening current accounts, we may can deposit for savings account also. But interview is much needed because to find out with the customer whether needed a current account, needed a checkbook, because it's very important issuing a checkbook. Can be misused and it may create a problem later on to the bank. Number one. Secondly, the authority to open account. Who is authorized? Individual, sole proprietors, no problem. Partnerships and joint accounts, no problem. When it comes to partnerships, authority to open account, that all the partners are jointly and severally liable for all transactions under Partnership Ordinance 1894. Therefore, all the partners has to sign for opening of account. When it comes to companies, limited liability companies, maybe private limited company or public limited liability company or limited by guarantee, whatever company coming under Companies Act, it has been, the resolution should be there to authorize a director to open the account, one or a few directors. Then comes to the language. Which language you are giving the mandate? Which language you are giving the mandate? Practice of the banking and certain case, that was a case also for this, that language should be mandate during the application should be the language where customer signs his signature. Where the customer signature is concerned, in that language only we have to give the application. Okay. So signs in singular, singular mandate. Signs in English, English mandate. Signs in Tamil, Tamil mandate. If any other language, then there's a certain requirements are there. I'll discuss the next slide. Okay, so the language should be the language of the signature. And maintaining of the minimum balance. Right? So that means operating an account, maintaining an account, we have certain expenses, what you call our cost. So maintaining cost is branch to branch, bank to bank differs. And we fix a minimum balance to be maintained in the account because that the cost of maintaining that account. Then comes the cross-selling. When you open an account, customers comes, we try to sell our other products also to the customers. Sometimes maybe credit cards, children's savings accounts, certain endowment packages like that, cross-selling and to keep. To open an account, if the customer is not coming, what is the position? Customer send the application to somebody third party. Can we open account? Current account, interview must be there. Without interview, we are not open to open. For other accounts, of course, there is no need of interview. Anybody can collect the application, like and do. But to open the account, customer must present. Right. There are certain parameters. If it's a current account, customer must present. If the customer is not present, we may open the account on behalf of the customer and not issue the checkbook. Even we are not posting the checkbook, registered post, customer has come to the bank and signed the vouchers and obtained the checkbook. Because signature has to be verified with the customer, specifically for current account. Therefore, customer should present at the time of opening account. But we have to verify the signature before issuing the checkbook, whether tally with the mandate. Therefore, without customer not present, checkbook will not be issued. Similarly, savings account also can be opened. FD also can be opened. There again, we should not issue the passbook or the receipt. If the customer make a request, written request, we may send it by registered post. Passbook and the FD receipt can be sent by registered post with the customer's request letter. Right. So, to different type of accounts, we have to understand the legal requirements and practice of banking. Two things have to be fulfilled. Okay, for the current accounts, we had earlier this heavy operating accounts, we charge a commission, now it's cost no more there. So it is in the competitive environment. So we have deviated most of the requirements. The heavy operating accounts, a lot of checks are coming in, and cost is very high. Operating cost is very high, those customers. Right? So if the bank needed, we may enforce the minimum balance can be increased. Minimum balance can be increased for such customers to cover up the cost of operating account. Okay. Then in the current accounts, most very important factor is introduction. Right? Why current accounts so important for a bank? It is because one factor is the deposit mix. Current accounts are zero cost, maintaining at a zero cost. Therefore, one thing.
Excuse me, sir.
Yeah.
Sir, can a person deposit a payment checks into a saving account without using a current account?
Yes.
What I try to ask you was without a payee name on the check, can that cross check can be deposited to a saving account?
Very good question. Actually, we to collect savings checks, we may accept the checks for savings accounts, providing there are 4 ways of collecting checks. Right? Number one is checks. If the check is drawn in favor of the bank, the payee is the bank, then we are collecting a check. The holder for the the value, right? Secondly, we can purchase a check and deposit. Customer may not like because that will be a commission. Thirdly, we can, as it is, accept only thing is that's why A-class signature is needed because you have to verify the genuineness and the bona fide of the title of the check.
Okay, sir.
So if it is there, manager can take a risk and collect a check. But we are not collecting open checks.
Okay, sir.
Savings account, we are not opening check. It should be either in the payee should be the account holder or the bank.
Okay, sir.
Otherwise, we are not collecting savings account. This what you call open checks.
Okay, sir.
Now the problem at present, what we are having this problem is be carefully because most of the customers are putting the checks to the savings account into the box.
Okay, sir.
So we have the right to reject the what you call collection.
Okay, sir.
No, without whenever deposits to savings account, normally we get a class signature to verify that about the genuineness of the check. So if you put in the box, you may immediately give a call to the customer that refuse collection.
Okay, sir.
You can refuse the collection, ask the customer to come to the bank and verify if you are satisfied, you may collect it. If you are not satisfied, you may reject it. Okay? So some changes, this is the problem we are having. Because the customer putting the checks in the deposit in the box and going, we are not verifying the account because the numbers are going in one sequence. Not like those days. Before this technology invented, the numbers are, we can identify the savings account with numbers. But today, numbers are going the same sequence. Therefore, it's difficult to identify whether it's a savings account or a current account. Therefore, verifying the signature collection, you have to verify the account also whether this is collected for savings account or not. Okay?
Thank you, sir.
Okay,
Thank
right.
you.
Right. So the deposit mix is very important for us because the current accounts are low cost funds. Funds are not low cost. And also when we have what do you call if any branch having higher value of deposits, say current account deposits, that branch operationally make profits, because savings account and fixed deposit have to pay interest. So deposit mix is very important to to maintain the operational expenditure of a bank. Then the profitability, current accounts, because current account zero cost and is profitable because the products attached to the current accounts are what you call commission earning products, right? And service charge they will charge because service charges because to cover up our minimum cost, right? To operate an account, we have a minimum cost. If the customer not maintaining that minimum balance, we can charge service charge to the customer to cover up our cost, or else we have to close the account. Right? Because there's no interest cost, that's important current accounts for us. Right. In opening current accounts, the most important is introduction. Who are eligible to introduce the customer? Basically, we ask a customer, current account holder, to introduce the customer for a bank. If you read the clause, introduction clause, that the introducer says that he is aware of that customer and he is suitable to bank with a person to be fit and proper to conduct a current account. That a guarantee is given. That does not mean the introducer taking the responsibility of the prospective customer. No, he is not taking the responsibility. But we have to clearly see that the introduction has done by a acceptable customer to the bank. If the customer, that introducer having number of check returns and bad conduct, that customer we are not accepting to introduce another person. That's very important. Okay. Then why introduction is needed? Very important case, Kulatilaka versus Bank of Ceylon and Kulatilaka versus Eastern Bank. Those are the two important cases were there. Specifically, Kulatilaka versus Bank of Ceylon case, where bank was found guilty without getting an introduction about the customer opening of account. So it became mandatory thereafter. Okay. And other introduction is the important one is, I think I have it. Oh, yeah. Right. The mandatory know your customer KYC regulation under FTRA Act number 6 of 2006. This is very, very important because there are three acts came in the 2005 and 2006. 2005 came Anti-Terrorism Act, Suspension of Terrorism Act, then Money Laundering Act, and Financial Transaction Reporting Act. Under these three acts, it became mandatory to know about the customer before opening account, about his background. So under KYC, we have printed format we are using. We ask the customer to fill it up and give. We just file it off. And there are four components in this KYC. Right? So that KYC has to be looked into carefully and it has to be updated regularly. Right? The KYC, know your customer, is a framework for banks which enable them to know, understand the customer and their financial dealings to be able to serve them better. All banks have been advised by the Central Bank of Sri Lanka to follow certain KYC guidelines. What are these guidelines? Know what you should know. True identity of and personal information, address, financial information, beneficial ownership of the accounts. We should know what is the background of the customer, his personal information, what is his employment, whether his spouse is employed, spouses employees. And if the address is NIC address and the resident address is differs, then address proof in documents. These are according to the guidelines we have to verify. then who should know? All the employees, all the bank employees, the branch employees, relationship manager should know about the customer and his background. It's a must, needed. Then the customer who maintains an account establishes a business relationship and whose behalf account is maintained, and one who carries potential risk through on and off transactions. It is important to have customer regularly updating his information. Now, this is a very important part. When you open an account, we fill this format. The first part is about personal information. Second part about his customer's income, source of income, what is the range of income, that has to be there. Thirdly, politically influenced persons. That means what are his contacts. So mostly this politically, this one actually mostly we have misunderstood. This is not politics. If any person's capacity, position can be influenced for any misconduct or a fraudulent transaction, that person is called political influence people. Any terrorism activities and relationship with the terrorism activity. So this declaration, not the customer, bank has to fill. And it has to be regularly updated. For example, if the customer's income levels changes, then you have to verify that. See, we have to feed into the system what is his income level, or what is his, what level is maintained. For example, say monthly deposits are, we say 100,000. So any transaction goes beyond 100,000, we have to report to the, we have to verify from where it is coming and what is the source of income. If it's coming regularly, continuously, if it's increasing, then you will update the KYC forms. So this is ongoing basis, you have to do it. Okay. Then,
Excuse me, sir.
Yeah.
Excuse me, sir. Another question. Is a business person must open a current account? Is it a must? Opening a current account is a must, or either he or she can continue his business with a saving account instead of, like, let's say we are not using check payments.
That's exactly.
Yes.
That's exactly. If you are not using any checks for many payments, it's just compulsory now.
Okay, sir.
It is not compulsory to maintain a current account because if you are not using the checks. But on the other hand, if he is operating a savings account in a commercial sense, that is for a day he's depositing about 10-15 checks every day,
yes,
then you have to ask him to open a current account.
I see, sir.
If you deposit once in a way 2 or 3 checks, doesn't matter. Let it be in the savings account.
I see.
But if the operations are heavy, then you have to ask him to open a current account, not allowed to operate a savings account in that manner.
And may I ask you why, sir? What's the difference between that, and why would that person is prefer to ask to open a current account when he's
depending on the thing is sometimes current account minimum balance is very high, and right. So then we can, if the customer is not asking for any check returns, customer is avoiding the overdrafts, services. Yeah, the only thing is getting the services of the bank to clear his checks.
I see. Thank you, sir. Yes, it's clear. It's more clear now.
So he is using the savings account to clear his checks. So it is actually, for us, it is a operational expense. Our operational expenses are high.
I see. The partner's purpose is to clear the payments.
Just to clear the checks. So if the objective is that, we may ask him to open a current account.
Open a current account. I see. Okay. Thank you. It's so clear, sir. Thank you.
Right. So the licensed commercial bank, following information should be obtained from prospective personal customers, customer's name from an original document issued by an official authority, It will be preferably be a photograph of the customer, such as national identity card, passport, or driving license. The reference number of such documents should be recorded by the bank. Customers' permanent mailing address and supporting evidence, which should be confirmed through correspondence. The authenticity of and integrity of the introducer and his own identity should be established to satisfaction of the bank. Independent verification of introducer's address should be made and filed with the mandate. These are, when opening a current account, specifically these things are very important, because this is given by the central bank guidelines under the circular, right? In respect of all types of accounts, return letters and statements should be followed up. This is operational side of the, not only opening, this operational side. Any letter returned by the postal authorities has to be filed in with the mandate or with the customer's file, customer's correspondence file with the envelope. Okay. Envelope is one of the important documents to prove later why the reason that because the postman, right, postal authority has written on the reverse, why the reason that it has not been delivered. Whether closed door, customer not accepted, Bharagattine, මෙවැනි අංකයක් නැත මෙහි නොමැත that type of remark is there in the envelope. So the envelope has to be attached to the letter and file it and keep it up. Okay, that's very important. So if subsequently customer comes and complains that they have not received, then we can show that this is we have sent and we are not liable for that. Okay, to protect ourselves, it has to be properly filed and kept it. When after opening an account, the features of the transaction as known as the time of opening of account changes significantly, causing grounds for suspicion of criminal activity, inquiry should be made with regard to the changes in the financial position and nature of activities which should be recorded. I told you the customer at the time of opening account, he mentioned his income is 100,000. After the sometime later, the operations are much more than that. Then we have to make an inquiry on that and find out from where he get the funds. We have to make an inquiry, and that has to be recorded and kept it in the mandate. Retention of records and evidence of identification as set out above should be maintained for a minimum period of 5 years, even after the account is closed. Why is that? Why is that? After closing accounts also, customers' correspondence file must be maintained for a period of, according to central bank guidelines, 5 years. It should be legally 6 years. It's under the prescription ordinance. Under prescription ordinance, any correspondence regarding it has to be kept for 3 years. Central bank want to keep it 5 years. Any contract, it is 6 years. This is the prescription period. So within the prescription period, we should not destroy any of these documents. It should be kept for further legal requirement has to be produced. Right. Where the officer handling the current account opening has reasons to believe that a new relationship may expose the bank to significant reputational risk, he may refer such requests to an officer of high authority before opening the account. What is this? Reputational risk. So this is there in the central bank guidelines, a separate letter saying that if you refer to the Qic report, where in the Qic it has been reported check returns, so lack of funds, and if any account has been closed for unsatisfactory conduct, that is overdrawing and not settling the overdrafts, not settling the bank charges. If your account is closed, that particular customer, you cannot open account, you have no authority. It has to be referred to your higher management, get the approval. It's a reputational risk. Now, prevent to the customers to go bank to bank. One bank you're opening and the closing checks are bouncing left and right. Then the account closes, you go to another bank. To avoid that, the central bank has introduced this with a crib to report to the crib. If there's a check return that is called bad remark of the customer, because check return means what does it mean check return? Financial indiscipline. He is not financial discipline, he is maintaining accounts. So therefore, indisciplined customers, we should not entertain for opening accounts. It's a reputational risk for the our bank also. So we should not open immediately because bank managers, delegate authority had been withdrawn such customers. It has to report to a high officer. The internal control auditor may be required to ensure compliance with the bank's policies, customer acceptance, and identification. So comply with the bank policies. Okay, so let's go back to our this one. The other one is important signature. So I just earlier mentioned about the you have to give the mandate according to the signature. What is the signature? There are different types. Signatures are signature should be not easily traceable. There are some customer signatures are very clearly anybody can write. Those are eligible signatures. So vulnerable signatures. When you find the customer open specifically for current account, not for savings, right? Current account, if you're having a customer signature, easily can be fraudulently written, forged, easily forged, then we have to take a precaution action. What is the precaution action? These are not we have gone out of the bank's practices. We had in the early days, in such customers, we are opening account and getting an indemnity signed by the customer that we are not liable for transaction of that account. Any fraudulent signature present for payment and if you are paid for it, bank is liable. If the signature is not the customer, according to law, there's no order to pay. There's no mandate to pay. So to protect ourselves, we have to take a indemnity. There's a printed indemnity form in the banks. I don't know. I'll try to get it still. I'll try to go to the branch and find out whether it's there still, at least in our stores, may not be in the counters. Anyway, then the other one is regarding the eligible signatures. If you find any signatures easily traceable, we had a practice in those days. Check leaves to be authenticated. Issue 5 or 10 check leaves, and it should be authenticated by the bank. 2 officers has to be initial. Put a rubber stamp, signature, authenticated. Put a small round stamp, and place of signature initials, and it has to be registered in our books. Signature authentication register, and issue the check leaves after the authentication. So you can prevent the bank and this responsibility of the customer to keep the checkbooks because they already signed under safety. So these are some practices we had to protect the fraudulent transactions in the current accounts. Then comes the scanning procedure. Now this is another important factor. Whenever customer sign the mandate, the signature, give a signing pen to sign the signature, not the ballpoint pen. Not, okay? Either signing pen or a gel pen to sign the signature. Why? When you sign by the ballpoint pen, the flowing of the ink is scattered in some areas. So when it goes to be scanned, put in the system, the signature is not legible. Signature in the scanning, signature is not legible in the screen. So it will lead, sometimes you, in your branch, you can refer the mandate to signature, whereas the checks have been presented to payment for other branches. Then there will be a problem of verifying the signature. Therefore, always any sign signature of a document has to be, earlier we had a system, should be an ink pen. There's a certain regulations were there earlier, but we cannot adapt those things now. But you keep a signing pen with you. When you open an account, use the pen to customer to sign that accordingly. Okay. Now see, when you go for a wedding house, register is having that pen, no? Register giving you to sign with that pen, not pure pen, not ballpoint pen. He is giving a signing pen because the signature, the ink had to be merged up into the paper. Fraud කරන්න බෑ. ඒකයි idea එක. Okay, so the signature is one of the important things. Get a document signed, any document, get a signing pen used for that. Okay, now when this comes for the over a period of time, if the signature has to be changed, if the customer want to change the signature, or when you return a check for remark, signature differs from specimen, you have to get a fresh signature card prepared. So for that matter, you have to get a signature card. You cannot change the mandate thereafter. Mandate signature, so you have to get a fresh signature card separate for that matter and attach the signature card to the mandate and get the new signature scanned and put into the system. These are some of the practices. Good practices we have to adapt. Right. Next one is about the initial deposit. What is initial deposit? Be careful about initial deposit. And sometimes you may find you ask for a certain amount of initial deposit. Customer comes and deposit that amount and get the checkbook. Before you going out, you don't entire money and going. So end of the day, to post the cost of the checkbook, funds are not enough. Account first day itself, account is overdrawn. Have you come across that type of customers? Okay, so initial deposit, see whether the customer is able to maintain that initial deposit. We put large amount initial deposit because to curtail intake of this unauthorized, unwanted customers. And the minimum deposit requirement is very important. The initial deposit by a check, can you accept? Initial deposit by a check? You can't. Why? Little while ago we discussed that. Section 82 of Bill of Exchange Ordinance says, right, you can collect a check. There are 4 things I had mentioned. No? In good faith, without negligence. Yeah. For a customer. So before opening account, he is not becoming a customer. After receiving the offer is there, acceptance is there. Where's the consideration? Check has to be realized to accept the consideration. Therefore, till the check realizes, there's no contract. So without contract, if you collect the check, if it's a fraudulent check, you're liable. Because that's why you can't collect checks as initial deposit. At least some money has to deposit. Even a 1 rupee per deposit, that will be okay. Right? Even 10 rupees or 5 rupees has to deposit, but not issue the checkbook till the check is realized. So these are the legal impacts on issuing the collecting checks. Okay. Okay, this regarding this one, a long time before this circular was issued, 25th March 1997, by the Director of Central Bank Supervision. But now only this has been implemented by the banks. Right. I wish to draw your attention the high incidence of check returns, which has become a serious matter of concern in view of the impact it would have on integrity and efficiency of the payment system. The commercial banks are therefore requested to draw the attention of their customers to legal consequences that may be encountered in the event of a check return. Section 25 of the Debt Recovery Act number 2 of 1990. Section 399 and 400 of Civil Procedure Code. These are the legal repercussions of a check return. Civil Procedure Code ekak Debt Recovery Act number 2 of 1990, Section 25. Pay the attention of check returns. Therefore, Central Bank, viewing these directives in 1997, screened the prospective customers before opening current accounts by calling information from other banks about their status. Now this is become mandatory because that's why we now become mandatory by check returns has to be reported to CRIB and you have to refer the CRIB before opening accounts. Okay. Okay, what type of accounts we can open? Individual accounts, joint accounts, sole proprietorship, partnership, companies. So what are the documents you needed? Specifically, I am not going to details. Sole proprietorship, the individual and joint accounts, the original, the normal, the what do you have? Mandate, KYC forms, NIC, copy of the NIC are the documents you needed. For companies, the partnerships, same thing, and registration, sole proprietorship partnership, you have to get the registration. Okay, the companies, it can be a public company or a private company. The certificate of incorporation is must. For public company, certificate of commence of business can obtain, then memorandum and articles of association, resolution to open account, resolution for appointing of directors to authorizing to open account. Two resolution must be there. Then list of directors, Form number 42 has to be obtained. Some of the documents. Then opening accounts for societies, clubs and associations. Normally we call not legal authorities, clubs and societies. The documents you need at the constitution of the society, clubs and association, duly certified by the secretary and the president, and resolution passed at the general meeting to open account, and the resolution of the general meeting where office bearers were being appointed at in addition to that, all the other what you call strategy requirements are KYC forms and national ID card copies of the office bearers. Okay, these are the requirements. Now there are certain organizations coming and falling under this category, right? That is trade unions. Trade unions are the Commission Association. We have to get the registration of the trade union at the Department of Labor. It has to be registered at the Department of Labor. So any 2% can start a what do you call with the Samiti or the can start, right? So you have to get the, in addition to all the other documents, get the registration from the Ministry of Labor. Okay, Department of Labor. Then you get, there are certain other clubs, areas, shrines, temples, churches. Opening of accounts for those are clubs and societies. So if you get Muslims, you call Muslim mosque and madrasas don't open account, right? So basically you have to get the document called what do you call the office bearers, certified by the Waqf Board of Muslim Affairs, Department of Muslim Affairs, Waqf Board, and all, other than the normal all documents, identity card, and this one. So Waqf Board requires certification should be there, the appointment of office bearers. When it comes to Hindu Koils, we don't have any other normal regulations, normal way we can open. Opening of for temples, again we discussed earlier, the major requirements, what is the requirements to get the approval from the, for the temple, we have to get the approval from the public trustee. When it comes to churches, right, churches, you have to get the approval from the bishop, archbishop, to open an account. Right, these are the normal requirements to open account. And government accounts, opening of government accounts and government schools are actually, we have to get the approval. The request will be made by the GST. The Deputy Secretary of the Treasury will be requested to open accounts for the government accounts. When it comes to provincial government accounts, it's the Chief Minister who is authorized to open accounts. Then we have executors and administrators. Who are executors, who are the administrators? So only current accounts. Executors are where if a person dies with the last will, person dies with the last will, then that last will has to be produced to the courts, district courts, and get a probate order. When a probate order issued, the court will appoint the person to manage the estate of the deceased person. It's called executor. It's called executor. Where a person dies without the last will, where his wealth is more than 4 million, then the court will appoint a person called administrator to manage the estate of the deceased person. So those accounts are current accounts in the authority of the courts that can open. When it comes to cooperative societies, only People's Bank has authorized to open accounts for cooperative, multi-purpose cooperative society, or the present time we call business cooperative societies that call the present change the cooperatives are coop cities. We have only People's Bank have authorized to open account. No other bank has authorized under People's Bank Act 1962. Why is that? Only People's Bank is allowed? That's because People's Bank has established with amalgamation of cooperative banks. 3 cooperative banks have been amalgamated, and 49% of the shares belongs to the cooperative societies managed by who called Director of Cooperative Development. Commission of Cooperative Development is the authority for 49% of the shares. 51% of the shares belongs to the government. Right? Therefore, because the 3 cooperative banks have been amalgamated and started by Thomas T.B. Langaratne at that time, Minister of Trade, People's Bank was established with that. That with the condition, cooperative societies has to maintain their current accounts in the only with the People's Bank. But subsequently, there are some changes taken place. Non-business cooperative societies can open accounts in the other banks, right? So you may say lorry owners cooperative society, milk producers cooperative societies, like that. So non-business type cooperative societies are there. That cooperative society can open account with the approval of the again Commission of the Corporate Development in the provinces. Right. Next comes the lawyer's account. Is called lawyer's client account. Lawyers clients accounts. The lawyers can maintain accounts for clients which are not taxable. Even issuing checkbooks, we are not charging any commission on that. Right? Those are only purely to operate the the client's funds. Then comes the trust accounts. Normally, trust accounts, we are not trust account where a person before dies, he will write all his properties and assets to a trust. Somebody will appoint to manage as a trust to do certain activities based on that assets and properties. Now, these trust accounts are actually legally little cumbersome. Therefore, normally we banks don't accept this opening accounts. So normally we ask that any trust forwarded to public trustee to take over and maintain. Okay, that are the accounts are non-resident accounts, international foreign accounts and foreign currency accounts and miscellaneous accounts. Right. Now it comes to the controversial issues. Most of them have question, didn't ask this question, but in the mind. Now I told the minors does not have contractual capacity. Below 18, minors can't open accounts. But we are having minors accounts. We are having minors accounts. What are these minors accounts? How to open this account? And how to operate these accounts. Minors accounts can be opened by parent or a guardian. Minors account can be opened by a minor, on behalf of the minor, the parent or a guardian can open account. It's now allowed by the central bank because it is needed request by the banks, authorized by the central bank to open account. The condition is these accounts cannot be operated, only deposits can be accepted, no withdrawals. After 18, that become completed, this account has to be converted into normal savings account or any other savings account, and where the minor can be given a mandate and open a fresh account, transfer the funds to that account, and allowed to operate that account. Until for 18 years, you can't operate that account. But only 4 instances authorized by the central bank where the funds can be withdrawn from this account. Number 1, for major medical treatment. If a minor has to undergo for a severe medical treatment, so a specialist or a DMO of a government hospital has to give authority letter, then you can withdraw the money. Second instance, for specialized educational equipments, not school books, annual school books, not that, or uniforms or other things, no. Special educational equipments, for that matter, with the principal of the school, if you are given a letter, you may consider to release funds for that purpose. Thirdly, if the minors are migrating with their parents, minors are migrating, then we may have to close the accounts and transfer funds. Fourth instance is we can allow one minor's account to another minor's account, transferring fund from one minor's account, one bank to another bank, right? Transferring minors to minor's account. and the fourth one. Right. Now the first two will take, that is education purposes, medical grounds. To whom you are giving the money? You can't give money. You can't give cash to the parents. No. There's no withdrawal slip cannot be filled. Why? That's a signature. Even the parent has signed, we are saying to give a withdrawal slip, there's a signature. This is not there. Therefore, we had issue a check pay order to the institution from where he's buying this, and we are buying this equipment for medical to the hospital or that institute, or buying educational equipment for that particular company, write a check directly to them, not withdrawing cash. Cash withdrawals are prohibited. If the miners are migrating, you can issue foreign currency to that value where it can go and use on the other country. Right? So these are 4 instances. The minus account can be operated and that one. Then it comes to the need has arisen with the minors where the scholarships has been given. Scholarships, where certain scholarships have been come, and the scholarship funds are there. We put in the minors account that cannot be withdrawn. That problem came. So the central banks allowed open account for any student above 14 years. Any student above 14 years, now they can open account. It's called over 14 or 16 years. 16 years. But central bank is given authority over 14 years to open account where the scholarship funds or anything can be deposited. There are again no withdrawals. No withdrawals from the counter. These students should be given ATM cards to withdraw from the ATM machine under the surveillance control of the parents. Okay. This is how the operating system of this particular account. Right. Now, what are the issues, practical issues that I come across? Now, we find in the Montessori's, it came across a problem, we had some problems. In the Montessori's, they also open minors account for their students. Who is the guardian? The teacher or the principal of this Montessori's. Children of the guardian. There was an incident where minors accounts, although accounts opened by the guardians or the teachers, the funds are collected from the parents. Funds are collected from the parents and deposited in that account. So one of the minor has died, deceased. Now to whom we are going to give the money? So this issue came to me. According to the law, the guardian has the right to get the money. Who's opened the account? If the parent opens the account, money goes to the parent. So keep in mind, this type of accounts you should avoid. Later on, if the problems comes, there's no way of, we can't settle all these problems, unnecessary problems. So when type of opening accounts, we'll look into that carefully. Okay. All right. Now let's go for the termination finally. And we see termination of the relationship. Relationship may be terminated by the mutual consent or unilaterally by one party. At the request of the customer, any time we can terminate the relationship, that can be close the account. Right? At any time, customer can request to close the account. So normally, most of the bank they are charging for closing, for that certain commission for that also. Earlier we did have this. Now, of course, everything has been money oriented. Anyway, so with the request of the customer, any moment, anything, any time, you can close the account. If it's a current account, if you are not operated properly, check returns, frequent ODs, and bank's commission has not been paid, settling and is overdue, which are considered unsatisfactory conduct. If a current account is unsatisfactory conduct, we should give 14 days notice and close down that account. Frequent check returns, frequent ODs, accounts overdrawn for bank charges and not settled. Those are unsatisfactory account. So give 14 days notice and close those account. So this is unilaterally bank can close those account. Continuously overdrawing for bank charges are included. Continuously overdrawing for bank charges, we can close those accounts. Unlike what you call the mobile phone companies, they won't close the account. They keep on overdrawing and going. That every month they add the charges, and when to have a big amount, then they try to file the action against the customer and try to recover. It should not be done by the banks. So whenever customers overdraw the bank charges, within 3 months it's still not paid, close that account. Then law enforcement, garnish orders, prohibiting notice, injunction orders, right? Either we may suspend or terminate the account. Then if the customer's assets are not sufficient to pay the liabilities, if somebody has filed action against that, then that customer becoming bankrupted. The court of all issues that customer is bankrupted, thereafter know that customer does not have any legal capacity to do a contract. So that account has to be closed down. Then comes the death of a customer. Individual customer death, contract between the bank and the customer terminates. Right? Joint account. One party dies, same position. The contract between the bank and the customer ceases. Therefore, be very careful to understand that even one party dies, we have to close the account. Because there's that particular agreement, the contract between the bank and the customer, joint account, no more valid, it is ceased. So fresh mandate has to be obtained and transfer the funds to that surviving party and operate account. Then comes to partnerships. Death of one partner, again same situation, contract between the bank and the that particular partnership account is seized. Therefore, existing partners may start another account and transfer this fund to that according to the requirement. Then comes to the director of a company dies. What's the position? Director of a company dies, right? Company is a separate legal entity. Directors are separate legal entities. Therefore, if a director dies, the account can be continued because it's a separate legal entity. So the board of directors has appointed another person to as a signatory can continue. Then it comes to power of attorneys. When attorney dies, no problem because the principal living account can be continued. But when the principal dies, attorney's power of attorney ceases from there onward. That account has to be closed. Okay. Then comes to the clubs and societies. Again, office bearer's death, nothing will happen, account can be continued. Okay. Then death of executors, probation, same way. A new person has to be appointed by the courts to continue the account. Right. Next, mental incapacity. If the customer finds that permanent incapacity, he is not in census, then the relationship can have to be terminated. In winding up of a company's business, you have to terminate the account, continue that business thereafter. Winding up of a bank, very reality, relationship will be over. One side of the party is over. Then outbreak of a war, this is actually so long within two countries with outbreak of a law. So enemy countries will be, relationship of the other country people will be terminated. Okay. So I discuss this. The case of a death of a customer, I discussed how to disperse the funds and how to disperse the funds in personal accounts and joint accounts. Okay. So according to the civil procedure codes, nominees can be disposing the balance in the account in the case of death of a customer. If there's a nominee appointed, how to do the disposal. With a last will, how to dispose. Without a last will, how to dispose. According to section 544A of the Civil Procedure Code, a nominee or nominees can be appointed for savings account, term and time deposit accounts, safe deposit lockers, treasury bills, etc. Nominees can be appointed. When the nominee is appointed, when the customer dies, only there's no other procedure, very simple. Ask the nominee to, if a nominee is a major, produce the death certificate. That's all. Close the account, transfer the funds to the nominee in the death certificate. In the identification of the nominee, the certificate and the identification of the nominee, they satisfy dispersed. That's all. No other matter. If the nominee is a minor, again get the death certificate and open an account for a minor account, transfer that funds to the minor account till the minor get matured, 18. After that, you can disperse. So very simple. Therefore, always we encourage to get nominees for savings account and 90% accounts. But nominees cannot be appointed for current accounts. It is not allowed. Okay. Then comes to where a party disease with the last will. Last will, you write last will and dies. So that last will has to be proved in the court of law to get a probate. No value. Value is immaterial. Right? If there's a last will, that last will has to be proved in the courts and get a probate to disperse the funds thereafter. The probate holder is called executor, who will be executing the authority. Next comes to Civil Procedure Code Amendment Act number 11 of 2008, Section 11, where Section 555, the Chapter 545, is given. No person shall effect any transfer of any property, movable or immovable, in Sri Lanka, belongs to or included in estate or effect of any person dying, testate or intestate in or out to Sri Lanka with 5 years prior to the effect in the transfer, unless grant of probate has been issued in case of person dying, testate, or letters of administration or certificate of heirship have been issued in the case of person dying, intestate, and leaving an estate amounting or exceeding 4 million rupees in value. If the value of the deceased person assets, total asset wealth, is over 4 million, then a case has to be filed at the district courts because he had died interstate, get a debt of administration or certificate of heirship. Right? So getting a certificate of heirship is very easy. It is not normally if the what do you call deceased person's legal heirs not going to contest for the assets or the wealth, then they can ask for a certificate of heirship. If they are contesting for the legal heirs, going to contest for this administration, and then there will be issue where the administrators have been appointed to be dispersed the funds. Okay, so that's all about today's presentation. So I discussed it in the morning about the operations of current accounts and the checking, negotiable instrument checks, payment of checks, collection of checks in detail. What are the legal requirements and how to operate these things in the summary form. Okay, any questions?
Sir, can you share the contact number with us?
Of course, yes.
Possible.
071
071
306
306
9515.
9515. 071 306 9515. Am I right?
Correct.
Okay. Thank you very much, sir.
So any question, any problem comes, practical issues, I'll be there to help you all.
Definitely, I'll contact you, sir. Thank you very much.
There are a number of people who have been contacting even now, far away places, a lot of problems. So daily I'm getting calls. That is early in the morning sometimes. Whenever we face for problems, there's no way to solve. So asking our advice. Anyway, so we are there. Till we are there, we can help. I don't know, next generation will be taking all this seriously for future. There's a gap. Okay, you will have to